Hello, I'm Edwin Turnage. I'm a Republican, member of the Greenville County Republican Party and a delegate to the upcoming convention. When I've attended the Tea Party meetings, a lot of people are interested in the lawsuit. I happen to be an attorney. I'm not a part of the lawsuit that the county has filed, but I have read the briefs. And so I'm making this video today to help explain what the details of the lawsuit are about, what the constitutional basis of our case is about, and also to help get you ready for a meeting on Monday where the Attorney General is going to come up and talk to you, so you'll be familiar with what the case that Greenville County is about. So when you meet the Attorney General, you have a good understanding of what the arguments we're making on behalf of the South Carolina Republican Party and the Greenville County Republican Party, both of which are parties to the lawsuit and plaintiffs in the lawsuit. The Constitution, again, protects us. The Constitution has a right of association. That means we can associate with, as a political party, with those people we agree with the constitutionally conservative group of people. When the state forces us into associations with moderate independents and even Democrats, that tends to water down our principles of constitutional conservatism. And it forces us to be involved with people who don't believe as we do. And it waters down the messages of our leaders. An analogy you might think about would be, what if there was a Christian church, and so, or you were a Baptist, what if you were a Baptist church and the state came in and said, well, you Baptists need to have open association, and we are compelling you to associate with the Catholics and the Methodists and the Episcopalians and the Presbyterians on your boards. And those guys all have to vote and who your pastor is and what kind of pastor you want for your church. That's the same sort of forced association we are compelled into when we have to go into open primary elections and vote alongside of these moderate independents, third-party people, and even the Democrat Party. First of all, before I get into talking, however, about the trees, sometimes it's a good idea to look at the forest. And so let me just briefly talk about the forest first. There's a political issue at the outset of this called registration by party. A lot of people have been working for changing the South Carolina open primary election law to a registration by party law for a long time, but it has not been done yet. Our current open primary law allows any registered voter to come into the Republican primary and cast a vote. That means our primary nominees are elected in part by moderate independent voters and even Democrats that cross over and vote in our Republican primary elections. So this is a really important issue in 2012, but the lawsuit really doesn't have anything to do with the issue of registration by party. The lawsuit cannot force the state of South Carolina into passing a law where we're going to have a primaries by registration by party. But it's super important, especially in 2012, because we're going to have a first in the South presidential preference primary here in South Carolina. The Democrat Party has already announced that they will not be holding a presidential preference primary. That means there's going to be hordes of Democrats coming over and voting in our Republican presidential preference primary. And then later, potentially, they could be voting in the primaries where we have our state senators running. But do you remember Alvin Green? A lot of Democrats believe that Alvin Green was elected because there were some Republicans who went over and voted in their primary. So you can bet that if we have an open primary, when the presidential preference primary is held in January of 2012, there's going to be plenty of Democrats coming over to vote for the worst candidate, and they're going to come over and wreck our presidential preference primary. That's why it's critically important that we get registration by party into law and enacted by the legislature before that happens. So we have a Republican governor, we have a Republican-controlled Senate, and we have a Republican-controlled House. Since we are the Republicans and we control everything, why is it that we cannot get a registration by party law passed? That'd be a perfectly constitutional and appropriate legislation to enact, and Governor Haley would sign it. The reason is because the RINO Republicans currently in office do not want a closed primary. They like it that moderate independents and even Democrats come into the Republican primary and vote, because that's who a lot of their voters are. So that keeps them in office. So that's the problem with getting this registration by party law passed. That's the forest. That's the problem. And because of that, the inability to get the state, the legislature, to enact a registration by party law, it has forced us to file a lawsuit, because the present election system in South Carolina is an unconstitutional system. The South Carolina system has basically two parts to it. 7-11-30, which is the 75% convention, nomination by convention statute, and section 7-9-20, which is the part of the statute that defines who's qualified to vote. That latter statute allows any registered voter to vote in a Republican primary. The only limitation is they can only vote in one. And again, the Democrats are not running a presidential preference primary, so they're this year, so they're going to swarm into ours. Our rights as Republicans, our First and 14th Amendment rights, are being violated by the present system. The right that's being violated is a right called the right of association. And there really is no question, if you look at the Supreme Court cases and the Fourth Circuit case that came out about this issue, there's no question that the present system is clearly unconstitutional. There is no good faith basis for anybody to come into federal court and argue that this law is constitutional. So what is the First Amendment right of association? First of all, it's a right to, as an individual, to associate with a party of our choice. So we as individuals have a right of association. But it also encompasses the party's right to decide what constitutes its association. The right of association by corollary means that we do not have to associate with people that don't believe as we do. Another important point about the First Amendment right that's been violated is that we have a right to control the process of how the Republican Party will elect its leaders or its nominees. There was a case up in the Fourth Circuit out of Virginia where the court ruled, and by the way, all these First Amendment rights, these are rights that the Supreme Court has ruled very clearly are constitutional rights of association that we all have as Republicans. There was a case in Virginia called the Miller case that came out that ruled the Virginia open primary system was unconstitutional. But in that court case, the court also stated that if a party has an alternative method to nominate candidates, then that is not a violation of our constitutional rights if there's an alternative. What the RINOs in the legislature have done is to create a system in which they give us what looks to be a choice but is really not a choice. And if you look at the two state laws, the two primary state laws that are involved in this, one of them is 7-11-30. That's a statute in South Carolina that defines the alternative method that we have to nominate our Republican leaders, and that is nomination by convention. Now, the state of South Carolina, through this statute, has described how we as Republicans are allowed to nominate by conventions, and they have put a requirement that if we choose to do that, we have to have 75% of the delegates at our state convention vote in favor of it. As a practical matter, that's an impossibility. First of all, it's not just 75% of the voting delegates that the legislature has said, but they have said it's 75% of all delegates at the convention. So considering you're going to have 5 or 10% not on the floor, back in their hotel room or making a telephone call or something, that means that the percentage is even higher than 75%. And if you think about it, why does the state of South Carolina get to decide for us as Republicans how we're going to decide who our nominee is going to be? And they've put this requirement of 75% on there for one purpose. They know it's too high to ever actually be voted on in that way, and especially in the state convention. They've done it for one purpose, and that's to create a sham so that they can argue that this is an alternative for how we can nominate parties, when in fact it's bogus. Everybody knows it's bogus. They know it's bogus. We know it's bogus. Anybody that looks at this statute knows it's a bogus sham statute that's designed for no purpose other than to create a facial possibility that's not a realistic nor a practical way that we'll be able to nominate as an alternative to their open primary election. The real threat of nomination by party, if we had one, if we as Republicans could decide our own process and decide that we are going to nominate by convention this year, and we vote as a majority to have a nomination by convention, if that were not illegal under state law, we could decide to nominate by convention, and someone such as Lindsey Graham might have a great deal of difficulty being the party nominee. Similarly, other candidates as well. If there was a threat that we could nominate by convention, if we could really and truly do that, then the legislature would quickly pass registration by party law so we could close our primaries and have only Republicans voting for Republican nominees. Now, when the Attorney General comes up here, he's going to come up here and try to persuade you why you should support his view that he's doing the right thing by filing briefs in federal court and arguing this sham system that the state has imposed on us and forcing us into association with Democrats. He's going to argue that he's doing the right thing by that. When we go to this meeting, we need to be prepared to confront him about why the system that the state uses violates our rights as Republicans, because it forces us to have associations with moderates, moderate independents, and even Democrats, and potentially this is going to wreck our presidential preference primary by all these Democrats coming over and voting. So there's no reason whatsoever that the Attorney General, who took an oath of office to defend the Constitution, should not first consider whether this statute is really and truly constitutional. Again, the laws are so clear that it's unconstitutional. He's made a terrible mistake. We should persuade him that he needs to go back to the federal courthouse and file a brief and say, I made a mistake, this law is unconstitutional, and ask the court to grant the relief that the South Carolina Republican Party has asked for. At the bottom of this video will be a link. You can read the brief that our lawyers wrote, which is brilliantly done. Again, I'm Edwin Turnage. I hope this video will help you understand what this lawsuit's all about and get you prepared for this meeting on Monday. Thank you for watching this video.